6 justices, 3 dissenters, 1 decision that turned concealed carry law in America upside down. And even now, most gun owners still do not fully understand what it actually gives them. Here in 2026, that same ruling is about to trigger a second shockwave, one that could erase every restriction your state rushed to impose after the first decision came down. I spend hours every single week digging through Supreme Court opinions, legal briefs, and court transcripts so you do not have to. The least you can do is hit subscribe right now and join the gun owners who get this information first. Because what I am about to explain could directly affect where you can legally carry, how you can carry, and whether you are fully compliant today. Subscribe now. Let's break this down. Here is what happened and why it matters more in 2026 than it did the day it was decided. The case is called New York State Rifle and Pistol Association versus Brune. The Supreme Court issued its decision on June 23, 2022. The vote was 6-3, and if you already hold a concealed carry permit, or you are planning to apply for one, this ruling reshaped your legal landscape. Most people heard about it. Very few truly understood it. Let's start at the beginning. Before Brune, there were about 8 jurisdictions in the country. 7 states plus Washington, D.C., where getting a concealed carry permit was nearly impossible for the average citizen. We are talking about New York, California, New Jersey, Hawaii, Maryland, Massachusetts, Rhode Island, and D.C. These places operated under what is known as a may-issue system. That is the legal term. In plain English, it meant a government official decided whether you personally had a good enough reason to carry a firearm. Not whether you were legally qualified, not whether you passed a background check, but whether, in their opinion, you had a special need. If you said, "I want to protect myself," the answer was usually no. Think about that for a moment. You are a law-abiding citizen. You pass the background check. You complete the required training. You follow every rule. And then someone sitting behind a desk in Albany or Trenton decides your reason is not sufficient. That was the reality for millions of Americans prior to June 2022. Then the Supreme Court stepped in. 6-3, the justices ruled that this system was unconstitutional. Under the Second Amendment, you have the right to carry a handgun outside your home for self-defense. A government official cannot deny that right simply because they disagree with your reasoning. Because of how the opinion was written, it changed the legal test for every gun law in America. Courts can no longer rely on broad balancing tests. Instead, the government must prove that any firearm restriction is rooted in America's historical tradition of gun regulation dating back to the founding era. That is a fundamentally different standard, and it has been reshaping lower court decisions ever since. Quick legal note: this is educational information, not legal advice. Always consult a licensed attorney in your state for guidance specific to your situation. Gun laws vary widely, and a qualified lawyer is the right source for advice about your individual rights. Tempsonly. What I am providing here is the broader legal picture so you can stay informed. Now back to the key issue. After Brune was handed down, the states that previously enforced may-issue systems did not simply concede. They responded aggressively. New York passed the Concealed Carry Improvement Act within weeks of the ruling. Since they could no longer deny permits based on vague and proper cause requirements, they shifted tactics. They created an extensive list of so-called sensitive places where carrying a firearm would be prohibited. Subways, restaurants serving alcohol, Times Square, large portions of New York City. The strategy was clear. If they could not stop you from getting a permit, they would drastically limit where that permit could be used. Other states followed the same playbook. New Jersey, California, Maryland, they each expanded their lists of sensitive locations where concealed carry would be banned, and those lists grew quickly. Here is a practical example. Imagine you live in New Jersey. After Brune, you finally obtain your permit. You are relieved. You are legal. You carry your firearm in compliance with the law. Then you discover that nearly every place you regularly visit, the grocery store, the movie theater, public transportation, the park, is classified as a prohibited location. You technically have a permit. But in reality, you can barely use it anywhere you go. That is what many gun owners experienced after states responded to Brune. If this breakdown has been helpful so far, here's something important. My next video will cover the specific language you should use if law enforcement asks whether you are carrying. There are 5 words that can make a critical difference during a traffic stop or any encounter. Make sure you are subscribed so you do not miss that. It may be one of the most important videos I release this year. Now here is where things take another turn. All of those post-Brune restrictions, the expanded sensitive place laws and new carry limitations are now being challenged again. There is a case currently before the Supreme Court called Woolford versus Lopez. This case will determine whether states were able to successfully sidestep the Brune ruling with their new restrictions. Here is the core issue. After Brune, Hawaii enacted a law stating that even if you possess a valid concealed carry permit, you cannot bring your firearm onto private property that is open to the public. That includes places like restaurants, bars, shopping centers, parking lots, and banks, unless the property owner gives you clear, explicit permission, either written or verbal. People following this case started calling it the vampire rule. Because under this law, you must be specifically invited in with your firearm before you can enter. Just like in old vampire folklore, where a vampire cannot cross the threshold of a home unless the owner invites them inside. That is how restrictive it is. Gun owners in Maui, Hawaii, filed suit. The case moved up through the federal court system. The Ninth Circuit ultimately upheld Hawaii's law. Then, on October 3, 2025, the Supreme Court agreed to hear the case. Oral arguments were held on January 20, 2026. 2 full hours. 2 full hours. And here is what nearly every major legal reporter said afterward. The conservative majority, all 6 Republican appointed justices, appeared to side with the gun owners. Chief Justice John Roberts stated plainly that the Second Amendment has often been treated as a disfavored right compared to other constitutional protections. Justice Samuel Alito told Hawaii's attorney that the state was effectively relegating the Second Amendment to second-class status. Justice Neil Gorsuch questioned why the government should be allowed to redefine property rights in a way that specifically undermines a constitutional right. Justice Brett Kavanaugh made it clear, if the text of the Second Amendment covers this conduct and there is no historical tradition supporting Hawaii's restriction, that should resolve the case. Even the Trump administration argued against Hawaii. The government's lawyer warned the court that if Hawaii prevails, states could begin prohibiting tenants from owning firearms without their landlord's permission. Quick heads up, the overwhelming majority of people watching this right now are not subscribed. That means when the Woolford decision comes down, a ruling that could directly redefine where your concealed carry permit applies, they will miss the full legal breakdown. Do not let that be you. Join the tens of thousands of gun owners who rely on this channel for straightforward legal updates. Hit subscribe. It takes 2 seconds. Now let me explain why the Woolford decision matters to you, no matter where you live. This is not just a Hawaii issue. Hawaii is simply the test case. So states like New York, New Jersey, California, and Maryland enacted similar laws after Brune. They all created lists of privately owned properties open to the public where concealed carry is prohibited. If the Supreme Court strikes down Hawaii's version of this law, those state laws will face immediate constitutional challenges. Here is a hypothetical scenario. You live in a state that currently prohibits concealed carry in restaurants, shopping malls, and parks that are technically private property. If the court rules in favor of the challengers in Woolford, those prohibitions could be challenged and potentially invalidated. Your permit could suddenly apply in far more locations than it does today, and we already have an early signal of where things may be heading. On the same day, the Supreme Court heard oral arguments in Woolford. The Fourth Circuit Court of Appeals, which covers Maryland and Virginia, issued its own ruling. In a divided decision, the panel concluded that Maryland's ban on concealed carry on private property open to the public is unconstitutional. All 3 judges, even those who disagreed on other issues, agreed on that specific point. That is not random. The courts are moving. The alignment is shifting. The momentum is building. Now here is what many people are misunderstanding. They believe the Brune decision was the finish line. It was not. It was the starting signal. The real legal battle is unfolding right now in 2026 at the Supreme Court. And the outcome of Wolford will determine how far your Second Amendment rights extend beyond your front door. So what should you do right now? First, understand your state's current concealed carry laws. Identify which locations are currently designated as off-limits. Those are the very places most likely to be affected when the Wolford ruling is issued. Second, if you live in a former may-issue state that has not fully aligned its permitting system with Brune, consult a firearms attorney. Your rights may already be broader than your state's guidance suggests. Third, stay alert. The Wolford decision is expected by late June 2026. When it is released, the concealed carry map of the United States could change overnight. This information has a time limit. The ruling could arrive any day between now and June 2026. When it does, the legal landscape will shift quickly. Subscribe now so you are notified the moment I publish the full breakdown. I will have it live within 24 hours of the decision being released. The video after that will walk through exactly what actions you should take in your state depending on how the court rules. Do not miss it. Let's bring this full circle. The 6-3 Brune decision was the most consequential Second Amendment ruling in American history. It affirmed that ordinary, law-abiding citizens have the right to carry a handgun in public for self-defense. It made clear that states cannot deny that right by demanding proof of a special need. In response, states attempted to counter by creating expansive lists of locations where your permit would not apply. Now the Supreme Court, whose majority appears sympathetic to gun owners, is preparing to decide whether those countermeasures comply with the Constitution. Your concealed carry rights are not done evolving. They are actively being defined right now. If this breakdown clarified where things stand, share it with one responsible gun owner in your life who needs this information. And subscribe so you are here when the Wolford ruling is issued, because that moment is coming, and it will reshape the national conversation about where you can legally carry in America. One final reminder before you go. Everything covered here is educational commentary based on publicly available court decisions and legal reporting. Nothing in this video constitutes legal advice for your individual circumstances. Firearm laws vary by state and are changing rapidly. Before making any decisions about where or how you carry, consult a licensed firearms attorney in your state. That is the only way to receive advice tailored to your specific situation. Stay informed. Stay prepared. Well, no.